Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney, Ms. Sheela Murthy, to discuss the latest updates, followed by frequently asked questions related to H-1B, GC, and other immigration matters. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We will start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. Please note the show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. For case-specific issues or concerns, please reach out to the attorneys for a private consultation. You all know very well Ms. Murthy is the founder, president, and CEO of Murthy Law Firm and Harvard Law School graduate. Also, she is the one behind the famous Murthy.com website. Before getting into the session, hi, Ms. Murthy, could you please briefly introduce yourself?
Thank you very much, Ranjit. Welcome, everybody. It's an honor and a pleasure to be here again with you this afternoon to go over some of the updates happening in U.S. immigration law and to answer some of your questions. As Ranjit has already just explained, Murthy.com is one of the world's leading immigration law firm websites. And the reason is it is so well known is because we genuinely want to help people sue the government when they're breaking the law, demand justice, do lobbying efforts through the American Immigration Lawyers Association and the American Immigration Council, and do whatever it takes to educate each of you about the latest changes in immigration law, to empower you, to enlighten you, and hopefully to give you the courage and the strength to respond if you get an RFE or a notice of intention to deny with boldness and confidence, especially if the law is on your side. If the law is not on your side, of course, then we have to deal with the uphill battle. So let's open it up, Ranjit, and get started. Thank you.
Yeah, yes, Murthy. Do we have any updates that you want to share us with? I think there is some lawsuit that was won by.
Yeah. So there was a very recent lawsuit, actually, just from Friday, and it's just been published. Just less than 3 days ago, where Adam Rosen, one of the attorneys at the Murthy law firm, filed a lawsuit against the USCIS to demand that they need to send notification if there is any type of RFE, either on the I-140 or the 485. In fact, the judge was so angry against the USCIS in this lawsuit because they told the USCIS, what is the point of sending an RFE after the employee has already ported to a new job, new employment, to send an RFE to the prior employer who obviously has no interest whatsoever in supporting an employee who has already quit or left their employment. So it seems like it was in the EB1 context, EB1C, the multinational executive manager for senior executives or managers. Clearly, this applies in all EB1 cases. We are hoping that the way because the judge made it clear that it absolutely should apply, but really the logic and the reasoning should even apply in EB2 and EB3 cases. We don't know if the USCIS is going to appeal this lawsuit. They probably will, because now they will have to find and actually start sending notification to the employees rather than just hiding under the umbrella saying, oh, employment-based immigration, it has nothing to do with the employee who is only the beneficiary. It is only the employer that we, the government, will deal with. So it looks like the government got a slap on the wrist. The judge was upset. We're hoping that this will translate into something, but be prepared. The USCIS may very well file the appeal, because I don't know if they want to be responsible. So until they file the appeal, at least they have to provide notification under this, specifically in the circuit which the decision was passed. Thank you.
Thanks, Ms. Murthy. We have a caller, Sumit from California. Hi, Sumit. Welcome to the show. Please go ahead and ask your question.
Hey, thank you very much for your support to the community. Hello, Mrs. Murthy garu. My question is about the I-140 downgrade, and there's a lot of talk going on between I-140 downgrade from EB2 to EB3. I would like to check a couple of points. One is about if someone is on I-140 EB2, what happens if it is downgraded to EB3? Does we also have the I-140 of EB2, or we lose the authorization of EB2, or we'll have only a EB3? Next question is, do we need to file a new perm or a new labor if file EB3 downgrade?
Okay, so Sumit, just so to understand, so it depends on how your lawyer actually filed the EB3 downgrade. So at the Murthy law firm, for example, we do not file it as an amendment. We file it as a new, we use the old labor certification. So to answer your second question, we do not need a new labor certification to do the downgrade. We use the previously approved PERM labor certification, which was certified by Department of Labor, use that and then file. Let's say you had an EB2 approval, like in your example, Sumit, we file a new EB3 case and the old case still stays valid. So God forbid you need it in the future, you still have the EB2 approval, and we do a new downgrade case explaining that we want to do an EB3, and then if the priority date is current, which is the only reason for you to do the EB3 downgrade, then file the I-485 with the EAD-AP and the I-140 downgrade all simultaneously or concurrently. But if the lawyer filed it as an amendment, then you no longer have the previous case, the EB2 approval still valid to be used in the future. So that's the reason we try to do it as a fresh, like a new separate filing to protect the employee, the beneficiary. But some people, I think either the lawyers do it or do it differently. You know, I'm sure they have a reasoned strategy. We just try to always protect the employer and the employee, both parties, in a manner that will only help everybody and not harm anyone. Hope that answered your question, Sumit.
That's totally answered my question.
We have another caller.
I've seen this question from many people. Thank you very much, Mrs. Murthy, and have a great day.
Thank you, Sumit. Take care.
Thank you, Sumit. We have another caller, Vishal from Maryland. Hi, Vishal. Welcome to the show. Please go ahead and ask your question.
Hi, Murthy ma'am. Thanks for all the support for the community. My question is regarding the same, like a lot of folks having the question regarding the H1B, the new petition which is selected in every year lottery. Once it is approved, anyone can before or on October 1st. Is it doable, or is it like risky thing, like transferring to another employer? Does it really require pay steps, or it will be any like ended up in a bad way, like doing like transfer, or can once it is approved later, let's say like after October 1st, employer has withdrawn for after like 1 week, that petition can be reused, or it will be not useful for any more.
So Vishal, let me make sure. So if a person has an H-1B petition approval with employer A, for some reason you either quit the employment, the employer no longer has a job offer, let's say in this situation, as long as you have to wait till October 1st you can do it beforehand, but if you're saying that the prior employer A revoked the H-1B petition approval, then there is a potential problem, because remember, with a cap subject H1 petition, Vishal, it is only valid after October 1st of the new fiscal year. So if the employer has revoked it before October 1st, that means even though the USCIS used an H1B cap subject petition, used a cap number for your approval, because it was pulled out, it was revoked before the October 1st start date, it's a problem. What we tell people is you can file before October 1st, switch from employer A to employer B, as long as it's not revoked. And then on October 2nd, the employer says, I'm revoking it because the employee hasn't joined my employment, but you have now switched based on that existing, for that 1 day that it became effective, you are now cap exempt. You are not counted against the fiscal cap. Otherwise, you have to again do it with the H1 lottery in the example where you've said the employer actually revoked it before October 1st. So you should not encourage the revocation, because they have nothing to lose. In fact, if they send the revocation letter dated October 1st, that will protect you and them, because after midnight on September 30th, automatically you're considered at 12:01 at midnight, a little after midnight, you're considered to have now triggered and started your H1. And if the employer says, please revoke it immediately, you can then switch to a file with a new employer beforehand, even before in September, saying, please use that cap number. So I know it's a little tricky. You have to be careful, and maybe the employer is not willing to support you because they're either don't have a job or they're upset about something. Thank you.
Thanks, Ms. Nithiin. Thanks for your advice. We have a question a lot of people have been asking about the I-485J. As per the AC21, a lot of people were planning to move to other companies after the 180 days, provided the 140 is approved in case of downgrade. But then a lot of employers are insisting not to give 485J and only they want to provide if there is an RFE. Can you explain the potential problems and, is it always good to proactively submit the 485J and what are the implications if not done, if you can explain?
Sure. Thank you, Ranjit. So the way I look at it, it's true. In general, my philosophy is don't provide information if it's not essential. But on the other hand, the USCIS, especially the AC21, the American Competitiveness in the 21st Century Act, which allows a person to change jobs to a new employer after the I-140 approval and the 485 has been pending for minimum 180 days. The law doesn't even require I-140 approval. It says it should be approvable when filed. So we just say, and the USCIS General Counsel has said it is much safer for it to be approved. So in those cases, as long as the I-485 adjustment of status has been pending minimum 180 days, you can take advantage of AC21 portability, change to a new job, as long as the new job duties are in the same or similar job occupational classification. So when an employer says, oh, you've joined my company, I don't want to file the AC21 paperwork or provide the supplement J, to me, that's a potential problem because, first of all, in a case like right now, we're at the end of the fiscal year. August and September are the last 2 months of the fiscal year. And so if they don't have the information, if they're ready and your priority date's current, they can actually give you an immigrant visa, approve your 485 and issue the immigrant visa number allocated to you immediately so that you get the green card approval, 485 approval before September 30th. But if you have an outstanding supplement J or you haven't sent that information and they have to issue an RFE for that, now that's going to waste precious time, which may result in delay in getting the green card. My philosophy in this is like, look, if you have nothing to lose, you've joined a new employer, all you need is a simple document signed by the HR or the supervisor or the director or whatever the company's policy is, signing the supplement J. That will only be helpful to getting the green card approved faster, etc. The only time it may not make sense is if you're switching to another job very soon and you'll have to send in another supplement J, then it may make less sense. But as soon as you join, if you know you're going to be there or you plan to be there or intend to work at that location, even if it changes later, I would send it in. And if you need to send another supplement J, you can. I don't obviously want to do it every few weeks, because it's more work and more cost and more tension. But if you think you found the right place, wait 2 or 3 months, but then just to make sure you're happy in the new job, and then go ahead and submit the supplement J so you can take advantage of it and hopefully get your 485 approved faster. Thank you.
A follow-up question, Ms. Murthy. What happens, let's say, if someone has not filed 485J and USCIS sends an RFE for whatever reason for something else? Will they come back and at the time, if we send 485J, will they come back and say, why didn't you file earlier? You should have done it. Is that going to be any issue that, you haven't filed 485J?
So we have never seen where they've said, why didn't you do it? Or, how come you waited? We haven't seen that as an issue because the law does not mandate it doesn't say within 30 days of starting a new job. There's no regulation. There's not even a policy memo or 60 days or 90 days. So they haven't really asked for it so far. If we have this discussion and somebody's watching, they may get ideas and start asking for it within a time frame. which could be problematic because if you either quit that job or you're unhappy or they fire you or terminate or that job no longer exists, then again, you would have to do a new supplement J. So they don't usually ask. The USCIS has not been strict about that, Ranjit, but in general, my philosophy is you want to get it, you want to file it, you want to have your case as complete as possible upfront in the beginning, so you don't have to, even some people, get the RFE for the medicals. And I know some people try to do that early on or, send it in advance. I think even in the latest things that the USCIS sent out last week with sending text messages and emails, they're saying, please keep it ready and send it with the RFE. Don't send it earlier, but don't take extra 2 or 3 weeks to get the medical and book an appointment. Finish it, keep it ready, because as soon as we send the RFE, if you send it back on the same day, there's a good chance you will be able to get the immigrant visa number before the end of this fiscal year, which is September 30th of 2021, because they're very worried because there's a lawsuit pending and they are concerned that I think we've talked about tens of thousands of unused immigrant visa numbers, which if unused would then flow over to the next, to flow down but it's annoying because they're supposed to do their job and issue the immigrant visa approvals and 485 approvals within that fiscal year because there's a quota issued by Congress on how many they're supposed to approve.
Yes, Ms. Murthy. Again, a follow-up question. So I'm concerned about this part. Like, let's say if 485J is not filed and then for somehow there is an RFE regarding the employer, not the beneficiary, but employer failed to submit some document or, whatnot. At that point, when replying the RFE, we say that I'm no longer with that employer, it really doesn't make any sense. And I don't know how USCIS is convinced that, I'm not with that employer. I've moved on last 3 or 4 months and now take this new 485J. I'm just concerned how that's going to work with USCIS.
Let me make sure I understand. You're saying if there's a change of employer and the person sends a 485 files the supplement J through the new employer, that there's a concern?
No. They moved to the new employer like 3 or 4 months ago and not submitted the 485J. Meanwhile, there is an RFE on 485, whatever, regarding the previous employer. Some document is missing, or let's say some information or whatever. Now, I don't think any previous employer would respond to that. And at the same time, we can say that, I have already moved 3 months ago and now take the 485J from new employer. I don't know how that's going to work with USCIS. Maybe they'll think that, it's your mistake that you didn't file on time and now, what happens at that point of time?
Correct. That's another good reason why to file the supplement J early and promptly, because you can say, hey, I already notified you. In fact, the part of the reason the judge was upset with USCIS was, hey, why would a disinterested prior employer have any interest to respond to an RFE on I-140 or 485 if you're only sending it to them? And so one of the big advantages to doing the supplement J is submitting it soon, within maybe wait 30, 60 days if you want 90 days, but don't waste months and years. In some cases, people have been with the same employer for 2 or 3 or 4 years, but they continue to not send the supplement J, which I don't think makes sense because you want to protect yourself. You want to do it reasonably promptly. And the argument that the judge just said is, if they issue now the RFE to the old employer, they'll say, we don't know that you changed. You didn't even bother to notify us. Whereas once you file the supplement J and you get the receipt notice for it, you can say, you had actual knowledge that I had switched. Why did you send the I-140 and 485 RFE to the prior employer when I told you I have moved from employer A to employer B? Good point.
Thanks, Ms. Murthy. That's why, burden of proof always remains on us. So it's better to send everything beforehand, not to get into, especially, how USCIS behaves at times, So better safe than, be sorry. Yeah. Another question here is one of the offline questions that we have is, someone has scheduled the H1B, H4 stamping in India. They are in India at this point of time, but then meanwhile, their GC got approved. In US and they have the cards in hand. No, what is the scenario? I know when you have a GC, I don't think you are eligible for H1B or H4 stamping. At the same time, how do we get this card over there? Is it possible to mail, or what are the scenarios? Because there is no other
Did
way
you
to
say that they
communicate with
already
them.
had the cards with them in their hand, or they?
No. I mean, they are in India. Cards are here in US, and the spouse is in India. The other spouse is in US, and they don't know what to do, so they ask this question. I thought mailing is a good option, but I don't know if that really
Yeah.
works, or how is it going to work? Because
Yeah.
I mean,
It's
that's the
a
only
risk. I
option I
mean,
see.
obviously, you don't want to lose the card in the mail. That would be the worst thing. I know people who've used passports are technically not legally permissible to be sent by FedEx, technically
Yeah, what I
speaking.
suggested was, better husband carry the green card to India and both come back together.
Yeah, that's another very good option. Some people use family or friends to carry the card, but the person's appointment, even if they get it, it would be an improper entry on H4. You don't want to enter on H4. Advance parole is permissible if the person has an advance parole. The
They didn't get
USCIS
the
in
EAD,
old
it
memos
looks
soon
like.
after AC21 came out, they allowed a person, even after the green card is approved, if you don't have the copy of the green card, but you have an advance parole approved by the USCIS, then you can use that advance parole to re-enter the US, and then they
Yeah.
don't consider that a violation.
Yeah, that's why I asked as well, but then they didn't get the EAD or AP, they directly got GC, it looks like.
By the way, that was what the USCIS originally had planned. A good way to save money was not to issue EAD AP, take the money for it up front in the high 485 fees, but issue the green card. If the priority date is current, issue the green card. That was the goal. So these people, on one hand, are very, very lucky because they didn't wait years and years and years for the 485. They got the green card approved. Of course, the logistical problem, but getting the card, the green card or the I-551 card, which is, permanent resident status proof, that should be easy enough to either send through a family friend, FedEx it, travel with it, and then both parties can come back safely without a problem. The US consulates are not supposed to issue the H4 visa or H1B visa for a person who's already a permanent resident.
Thanks, Ms. Murthy. That makes it clear. Another question a lot of people were asking is about the first time H1B stamping. Is it mandatory or necessary for the first H1B stamping to go to the home country, or they can go to like any other country nearby, like Mexico or Canada or Jamaica or any other country?
So a lot of consulates have restrictions on what they call TCNs, third country nationals. So you're not even allowed to apply, for example, in Mexico for the first time. You are required to have gotten it from the home country. And part of the reason why they prefer most people to go back to the home country to get the visa stamp is because that is the only country that may be trained about the particular university, whether it is legitimate or like fraudulent, background on the person's education, the credentials, the marriage laws. A lot of training is done for consular officers when they go to different parts of the world about each country's, culture and social norms and legal issues. And like in India, we have Hindu Marriage Act, where you don't have to get registered because the Indian Supreme Court recognizes a marriage under Indian law, even if there's no registration, which 9 out of 10 Americans don't even understand what that means. India has personal laws, the Hindu law, the Sharia, the Muslim law, the Special Marriage Act for non-Hindus, for Christians, Zoroastrians, and other religious faiths. So they just like you to have, for safety, security, for understanding the culture from that particular country's consular officers who are trained. They prefer you to do it. Now, some countries will allow you. There are problems in some consulates which are closed because of different reasons. So people, for example, from countries like Iraq or Iran, if their consulate is closed because of different reasons, war, etc., you can try to go to a neighboring country consulate and ask, and they will do favors depending on what the political situation and other risks are for the people. But in general, the general rule is you should try to go back for the first time so you don't have to deal with these risks.
So, Ms. Murthy, even let's say if there's a 221G, you will end up even going to the home country because you can't stay there forever.
That is a good point. Yeah, but
Thanks, Ms.
even they
Murthy.
will ask you about the 221, same, because they can see the information. I remember in the olden days, so some of us are much older, pre-internet, pre-computer, pre-consolidated databases, the CCDs, people would go quickly from Canada, they would run to Mexico or to Caribbean or to India and not tell the consular officer that I had just got a 221G somewhere else. Now those are from last 20 years, they can look up in 1 second and see that you got a 221G or a fraud or a misrepresentation or some problem. So we tell people, don't do consular, they call it forum shopping. Don't do forum shopping to search for the best consulate.
Yes, Murthy. And another question, follow-up question here. How about people who, let's say, have been residing in that country from let's say a year or two? Let's say someone has been working in UK for about 1 or 2 years and now they got H1B. Do they also have to go to the home country, or because they have been a resident of, let's say, UK or Canada or some other country, can they go to the local consulates?
So that is considered perfectly reasonable. If a person has especially not just a tourist visa or a pass-through visa, but an actual work permit or student visa or permanent resident or obviously citizen of that country, or even just a permanent resident student working, studying, they absolutely allow the person to apply, because even though you're a TCN, a third country national, you have valid long-term rights to study or work or reside in that country when you apply at that particular US consulate for whatever visa, H1 or H4 or B1, B2 or F1, etc. That's permissible.
Thanks, Ms. Murthy. You have another question? A lot of people were again asking about this travel and advance parole at this point of time, because there's a ban still in place. A lot of people were successful, but from the forums we have been hearing that consulate says it's fine, but then CBP says it's not fine. They've received some emails few people have shared. So what are your comments on it? If someone faces this kind of issue at the port of entry, what do you think is the best course of action they should take rather than going back?
The general rule is, if a person was issued the visa when the presidential proclamation preventing, or at least looking at supposedly applying against nationals of certain countries, including India, then the safe rule is you show that, and the CBP is supposed to honor that, because that means you are granted the visa stamp in the passport as an exception, as a national interest exemption. Exception.
Not that, Ms. Murthy. I'm talking about traveling on advance parole.
Oh, on the parole. So we've heard a couple people saying that some people are saying that it's not protected or not covered. Some CBP officers are saying there's no prohibition because a parolee is not seeking admission into the United States. You're only being paroled into the United States, so you shouldn't have a problem. A couple others are saying it is a problem, you're not supposed to get in. But the safest course, of course, is to avoid travel when there is a presidential proclamation that says a citizen of India is not supposed to be able to travel and re-enter unless they stay 14 days in a neutral third country that is not subject to the restriction because of the COVID-19 and especially the Delta variant, and now the Delta Plus variant. The other alternative is, again, like we talked about, forum shopping for consulates. Some people write or find out from friends, because some CBPs are not having any problems just changing their airline ticket. And let's say they think John F. Kennedy, JFK is very safe. People are just saying, okay, I'll spend a little extra money, but I'll just fly into a port where the district port director is much more flexible and understands the law and says, come on in.
Yeah, that sounds good, Ms. Murthy. And another last question a lot of people are having nowadays is about the H1 and H4 H4 and EAD premium. Do we have any update on when they are going to open it? Because I think it's in the final stages of rule making. And does it go through notice and comments, or how is it going to happen? Because this is through a Congress bill, actually.
Right. So actually, there shouldn't be, if it's a law, if it's a bill which was said there, it really shouldn't be, there shouldn't be any gray areas. But correctly speaking, to the extent it's substantively changing, it's not really changing anything. It's just allowing it to be filed under premium processing. It should really have gone through. But, with the government, whenever we say it's on an expedited fast track, that means instead of taking years, it could still take weeks, if not months, to process. And I know that's very, very upsetting because a lot of people rely on the second income. Sometimes the second income is more than the principal's income, depending on the occupation or the job of the dependent. And it's really not right because we're almost rewarding the government for their incompetence before they were routinely approving the H1 and H4 together with the H4 EAD, especially if it was filed under premium processing. We have apparently started seeing a few of those, but it has not become a major trend. So if it is that way, then for one fee, you can get all the three approval, the H4 and the H4 EAD and the H1B under premium processing. But that is no longer, the Trump administration made sure that they separated the H1 and the H4 to increase the time, to harass people, to collect more fees. And if any normal person, if you or I did it, if any other business did it, we would be in jail for fraud and for theft and for being corrupt. But the US government is doing a lot of things that I think are improper, unethical at the best, and illegal in the worst case, and getting away with it because it's the federal government. And that is why, as concerned law firms, as concerned individuals, as concerned employers, people who care, we need to absolutely sue the federal government and challenge people when they take away our rights and don't follow the law and the restrictions and the freedoms and the rights granted to us under the US Constitution for all of us, even if we are foreign citizens.
Thanks, Ms. Murthy. We are towards the end of the show. Again, thanks everyone for watching the show and calls. It was a great session with interesting topics. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy. This is Ranjit signing off. Thanks, Ms. Murthy. Bye-bye.
Thank you very much.